So today I'm going to speak to you about guardianship and intervention orders. Firstly, what are they? Both of them are orders granted by the Sheriff Court to enable a person or persons to make decisions for and on behalf of an adult who does not have the capacity to make decisions him or herself. The adult's lack of capacity could be caused by illness, such as dementia, for example, or by learning and developmental difficulties which the adult has had since birth. Anyone with an interest in the adult can apply. This might be a family member, a carer of the adult, a professional person, such as a solicitor or accountant, for example, or the Chief Social Work Officer of the local authority. A guardianship order gives the successful applicant, referred to as the guardian, powers to do certain things on behalf of the adult. These powers can relate either to matters affecting the adult's welfare, such as the power to consent to medical treatment, for example, or to the adult's finances, for example, to open a bank account for the adult, or it can relate to both welfare and financial matters. An intervention order is more specific than a guardianship order. The person appointed is called the intervener and will only have the authority to carry out a very specific action on behalf of the applicant, such as to deal with the sale of the adult's house, for example. Both of these orders are different to a power of attorney. A power of attorney is something which is granted by a person who has legal capacity, appointing another person or persons, referred to as the attorney, to act on their behalf in the event that he or she should lose his or her capacity. Application to the court for a guardianship order or intervention order is done by what is called a summary application. There are specific court rules which apply to such applications. There are also specific reports and documentation which must accompany the application. For example, to medically confirm that the adult does not have capacity, and reports to confirm that the applicant is suitable to be appointed as the adult's guardian. It is crucial that these rules and regulations are adhered to, otherwise your application is likely to be rejected by the court. Once the court has received an application for a guardianship order or intervention order, provided that everything is in order with it, a hearing date will be fixed. The court hearing itself will be heard in private in front of the sheriff and the sheriff's clerk. Generally speaking, what happens at the hearing depends on the circumstances of each case. It might be that the hearing needs to be continued to another date for some reason. If there is no opposition to the application and the sheriff is satisfied that all of the relevant parties have been notified and that it is appropriate to grant the application will be granted. To grant the application, the sheriff must be satisfied that the adult is incapable in relation to decisions about or of acting to safeguard or promote his interests in his property, financial affairs or personal welfare, and that this incapacity is likely to continue. The sheriff must also be satisfied that there is no other means which would be sufficient to enable the adult's interest in his property, financial affairs or personal welfare to be protected. A guardianship order is granted for 3 years or for a longer period, including an indefinite period, if the sheriff considers that to be appropriate and necessary. If it is thought that guardianship is still required when the order is due to come to an end, then an application to renew it must be submitted to the Sheriff Court. After the application is granted, you will be issued with a certificate of appointment by the Office of the Public Guardian. If you have been appointed as financial guardian, there are administrative duties which you must fulfil. The Office of the Public Guardian supervises financial guardians in the exercise of their powers and provides paperwork which must be completed and returned to them for approval. You may also require to obtain a special policy of insurance called a bondification. If this is required, you will not receive your certificate of appointment until the bondification has been obtained. You can find out more about power of attorney, guardianship and intervention orders on the Office of the Public Guardian Scotland's website. In conclusion, this is a fairly complex area of law and there are specific rules and regulations that apply. However, you don't need to worry, we are here to assist. Should you need advice in respect of this matter, please don't hesitate to get in touch.